We are the secretariat of the Conference of the States Parties, a mandate given to us in the Convention and confirmed by the General Assembly in the resolution by which the Convention was adopted. And we have now two major components. One relates to the support to the conference and the review mechanism, and the other one relates to supporting the development and delivery of technical assistance in the areas under our responsibility: anti-corruption and economic crime. In the area of anti-corruption, and as part of our support to the mechanism for review of implementation in the Conference of the States Parties, we are providing dedicated, specialized advice and assistance when requested. We do capacity building, we do training, we cooperate with other organizations, and we are helping countries with the development of strategies and anti-corruption policies. We provide assistance with legislative drafting. We also engage with the private sector, another very important stakeholder in this entire affair. The Convention starts with an article that states its purpose, and that has three elements. It speaks about preventing and controlling corruption, very general statement, but it also goes on to speak about international cooperation in criminal matters and technical assistance. In addition, it speaks about integrity, accountability, and proper management of public affairs. The Convention has a pillar structure. It is built on pillars that are represented by its chapters: prevention, criminalization and law enforcement, international cooperation, asset recovery, and that structure is supported by two other sets of provisions: technical assistance and training, and review of implementation. The Conference of the States Parties identified a key set of priorities. Those were, of course, the review of implementation and the establishment of a mechanism, an issue that was given as a mandate to the conference. One of the first things that it had to do was to start the work on developing a mechanism for implementation, but also the other priorities that were established at the same time were technical assistance and asset recovery. The mention of technical assistance in the Convention is the result of a very elaborate and very considerate process. It is the result of the understanding, the common understanding, that first of all, corruption is no longer a domestic issue, and secondly, that there will be weak links in the chain because of different levels of development, different levels of capacity or lack thereof, and consequently there is a need to not have weak links, meaning there's a link for the international community to rally around the countries that have needs, that have established, identified, benchmarked needs, and try and rally around those countries and make sure that those needs are met through the provision of technical assistance. The other element which is mentioned there is asset recovery, and here is one of the more innovative, groundbreaking achievements of the Convention. It is the first time that this issue is dealt with in an international legal instrument and in such a comprehensive manner.
The UNCAC, the United Nations Anti-Corruption Convention, is a very important tool towards which all governments have contributed, and countries in the region have become signatories, endorsed the convention. So there is an agreement that this instrument would help countries to improve the governance quality.